Yeah, I think it's imperative. As I stated before, when we talked about the insurance issue, is how is a board of directors going to evaluate what kind of exposure they have for any kind of claim that may be pending, whether or not it's just threatened legal action against the board or it's real action that's been filed, such as pre-suit mediation or arbitration or litigation. The other side to that is that you need an attorney to evaluate the strengths and weaknesses of the case, not just in liability or in damages, I should say, because that's kind of what we were dealing with exposure, but in liability as well. How strong is their case? How strong is the member's case? And sometimes you have board members that are attorneys and they think that they can evaluate the case and they don't need to have legal counsel. Well, it's really not their job as a board member to give the board legal advice, because that's kind of a conflict of interest, because the board is supposed to be listening to outside counsel and to an outside independent line of thought, as opposed to a board member who may already have other influences or made his mind up, or maybe he doesn't like the member that is asking for relief. And so that person skews their legal opinion because they have an axe to grind. So you want to make sure that you have an attorney to evaluate once an issue comes forth and how best to deal with it. If the property managers kind of cut it off at the pass, that's great. And you don't need to get the attorney involved. If it comes to the board of directors and the board of directors can kind of come up with an easy fix that they're comfortable with, they think that the members will be comfortable with, and that the member that has lodged the complaint or has threatened action, and if they take care of it, that's fantastic. But if it goes anywhere beyond that, you need to have an attorney to evaluate, and you may be able to, through correspondence with the member or the member's counsel, you may be able to work the issue out without going through any other sort of pre-suit action or litigation. Now, the other thing that's important is that if there is any kind of pre-suit matter that has been instituted against the association or litigation, then you have to have an attorney that represents the corporation, because the associations are corporations, and under Florida law, corporations cannot represent themselves in court. So if it's pre-suit and you have to have, it's required before you ever get into court, the association's required to have counsel, and if they either bring a lawsuit or if they are sued by a member or by some other third party that's not even a member, they're required to have counsel to defend that action. So the associations just kind of need to be aware that, or the board of directors, that when you're in associations like that, there are going to be requirements, and there are going to be times where they need to take an issue to the attorney and have the attorney evaluate that issue before they make any kind of decisions or votes on the matter. And then certainly they need one if they're going to do pre-suit or litigation.